Ever get that sinking feeling, after you sign a contract?
Oh, yeah.
Like maybe you should have read the fine print a little closer.
Mm-hmm.
Today, we're diving into the murky depths of agreements gone wrong, specifically when things like fraud and non-disclosure rear their legal heads.
And what's fascinating is how these concepts pop up in everyday situations, not just those high-stakes business deals.
Exactly. Think about this. You're buying a used bike from someone online. They assure you it's in perfect condition, but when you pick it up, the gears are shot.
Oh, no.
That right there is a classic example of potential fraud where someone makes a false statement to seal the deal.
Precisely. For it to be legally considered fraud, that statement has to be demonstrably untrue, presented as a fact, and made with the intent to deceive.
Okay, so it's not just about someone exaggerating a bit. There has to be real intent to mislead.
Absolutely. Now, let's say the seller doesn't mention the faulty gears, but knows they're a problem. That's where duty to disclose comes in.
So even staying silent can be an issue.
You got it. Legally failing to mention a material fact, something that would impact a reasonable person's decision to enter the contract, can be just as bad as an outright lie. And that's where things get really interesting. This idea is at the heart of a landmark legal case, Laidlaw v. Oregon, dating back to 1816.
Ooh, a historical case. Tell us more.
Imagine this. It's the end of the War of 1812. A savvy tobacco buyer, Laidlaw, gets wind that the war's end means tobacco prices are about to skyrocket. He approaches a seller Oregon who's clueless about the war's impact on the market.
So the seller asks any news that might affect the price, and Laidlaw just stays quiet.
Exactly. He doesn't lie, but he doesn't exactly spill the beans either. The court ultimately sided with Laidlaw, saying he wasn't obligated to reveal what he knew because that information was equally available to both parties.
So sometimes saying nothing is okay, but other times it's a recipe for legal trouble. What's the deciding factor?
That's where legal guidelines like Restatement Section 161 come in. This outlines scenarios where withholding information is considered fraud, like correcting a previous false statement, clarifying a misunderstanding of the contract, or speaking up if you know the other party is making a mistake based on missing information.
So Restatement Section 161 is like a cheat sheet for avoiding legal headaches.
Precisely. It's all about ensuring fairness and transparency in agreements, especially when one party has more knowledge than the other. Which brings us to another fascinating case with a real estate twist.
Let me guess, a house with hidden problems.
You read my mind. We're talking termites, and lots of them, in a case called Hill v. Jones.
Okay.
Imagine you're buying a house, and the seller conveniently forgets to mention the massive termite infestation munching away at the foundation.
So we've got a house with a secret snacking situation going on. What happened in the Hill v. Jones case?
Well, as you can imagine, discovering a termite infestation after you've bought a house is not a pleasant surprise. It's a classic example of a material fact that should have been disclosed. The court agreed, ruling that failing to mention something that directly impacts the value of a property is a big no-no legally.
That makes sense. You can't just sweep those creepy crawlies under the rug, literally. So we've covered outright lies and strategic silence, but what happens when opinions get involved? Can those land you in legal hot water too?
Absolutely. Especially when it comes to expert opinions, where one party has specialized knowledge. Think about it. You're more likely to trust the assessment of a seasoned mechanic about your car than, say, your neighbor who tinkers with his lawnmower on weekends.
Right, so a mechanic saying this car is a steal carries a lot more weight because of their expertise.
Exactly. And that brings us to a case with fancy footwork and legal lessons, Vokes v. Arthur Murray.
Ah, yes, the dance debacle. What can you tell us about this one?
Picture this. You walk into a dance studio, maybe a little unsure of yourself, dreaming of gliding across the ballroom floor. And here comes your instructor, full of compliments, showering you with praise about your natural talent, and how with enough lessons, you'll be the talk of the town.
It sounds like the beginning of a feel-good movie montage.
Well, it certainly did for Audrey Vokes, the star of this case. She was so swept up in the instructor's glowing reviews that she signed up for thousands of dollars worth of dance lessons. The problem was she wasn't actually improving as much as they led her to believe.
Oh, no. So what did she do?
She sued, and the court sided with her. This is where the superior knowledge doctrine really shines. The court recognized that the dance instructors weren't just offering casual opinions. They were professionals whose assessments carried weight because of their expertise. And in this case, they overstepped, using their position to sell far more lessons than Audrey needed or realistically benefited from.
Wow. So even if it's not a blatant lie, making overly optimistic statements based on your specialized knowledge can be considered misrepresentation.
That's the key takeaway. And it applies to so many situations beyond the dance floor.
Like when a doctor makes a medical recommendation or a financial advisor gives you investment tips.
Exactly. It's crucial to be an informed consumer in any situation where there's an imbalance of knowledge.
Ask questions, do your research, and if something feels off, maybe get a second opinion. It's like that old saying, trust but verify.
Couldn't agree more. And speaking of being informed, we've covered a lot of ground today, from historical tobacco trades to modern-day dance studios. Let's take a moment to distill everything we've learned into practical takeaways you can use in your own life.
So we've journeyed through tricky contracts, unearthed hidden termite infestations, and even waltzed into a courtroom showdown. What are the key takeaways our listeners should remember to avoid legal pitfalls in their own lives?
Well, it all boils down to this. Knowledge is power. The more you understand about your rights and responsibilities when entering A and Y agreement,
Yeah,
the better equipped you'll be to protect yourself.
makes sense. But where do we even begin?
It starts with a simple but often overlooked principle. Honesty is key. Whether you're drafting a contract or about to sign on the dotted line, being upfront about important details is crucial. Don't try to hide things or hope for the best.
So even if an expert gives their recommendation, I should feel empowered to ask follow-up questions until I truly understand and consent to what's being proposed.
Absolutely. And remember, if something doesn't feel right, it probably isn't. Trust your gut and don't be afraid to walk away from a deal if something seems off or you feel pressured.
This has been incredibly insightful. We've covered so much ground, from understanding the nuances of fraud and non-disclosure to equipping ourselves with practical strategies to navigate agreements with confidence. Any final thoughts for our listeners before we wrap up?
Remember, contracts are part of our daily lives, from buying a cup of coffee to signing a lease or even entering into a business partnership. By understanding the basic principles we've discussed today and approaching agreements with a discerning eye, you can protect your interests and ensure that the agreements you make are fair and mutually beneficial.
Couldn't have said it better myself.
Duh.
Thanks for joining us on this deep dive into the fascinating world of contracts and legal literacy. We'll see you next time for another deep dive into a new topic. Until then, stay curious and stay informed.